Welcome to our training regarding Florida laws, rules, and regulations for case management services. This lesson is an overview of the laws and regulations. We will not attempt a complete review of the laws and regulations during this lesson because, frankly, we would be here all day. Additionally, much of the information is discussed in other lessons in the curriculum. This lesson introduces you to the various laws and regulations and provides you with copies of them for your review and reference. In the lesson media section of this lesson, you will find copies of the following: Florida Statutes, Chapters 394 and 397, Florida Administrative Code 65E15, 65E4, 65E5, and 65D30, and then Florida Medicaid manuals, the General Provider Handbook, the Community Behavioral Health Handbook, and finally, the Mental Health Targeted Case Management Handbook. As a part of this lesson, you are required to download and review all of these documents. I do not recommend printing them all, as these items make up over 700 pages of documents. When you have viewed this entire video and downloaded and reviewed the attached files, you will be required to complete the attached quiz with a passing score of at least 70% to successfully complete this lesson. Finally, as a convenience for you, a PDF copy of the PowerPoint slides for this lesson is provided in the lesson media section. There are two main laws that define mental health and substance abuse services in the state of Florida. The first is Florida Statute 394, or the Florida Mental Health Act. This act is also known as the Baker Act. The second law is Florida Statute 397, or the Howell S. Marchman Alcohol and Other Drug Services Act. This act is also known as the Marchman Act. As previously noted, there are copies of both of these laws in the lesson media section of this lesson. When we hear people talking about the Baker Act or the Marchman Act, they are usually only talking about the sections of these laws that define the involuntary admission procedures. In fact, these laws include much more than just the involuntary admission process. They define and enable the entire mental health and substance abuse treatment services in the state of Florida. Before I move on from this slide, there is something I want to mention regarding the Baker Act and the Marchman Act that references the idea of person-first language. Too often we will hear people referred to as Baker Acts or Baker Act clients, or someone had to Baker Act or Marchman Act someone, or someone got Baker Acted. This language can be perceived as harsh, critical, and judgmental. The proper usage applying the principles of person-first language would be to refer to the person as a person who was admitted to the facility under the involuntary admission procedures of the Baker or Marchman Act, or a slightly shorter version would be to say a person admitted under the Baker or Marchman Act. We are first going to look at the Florida Mental Health Act. There are a couple of sections that deserve a brief discussion. First, in section 394.459 is a discussion of the rights of patients under the Mental Health Act. The basic rule that can be applied is that a person does not relinquish any of his or her rights simply due to his or her utilization of mental health or substance abuse services. The specific rights identified in the law are the right to individual dignity, the right to treatment, the right to express an informed consent, the right to quality of treatment, the right to communication, abuse reporting and visits, the right to care and custody of personal effects, the right to voting in public elections, the right to habeas corpus, and finally, the right to participate in treatment and discharge planning. Next, Section 394.460 describes the rights of professionals. While short, this section is important. It states that no professional shall be required to accept patients for treatment of mental, emotional, or behavioral disorders. Such participation shall be voluntary. Next, Section 394.4615 describes the requirements for the confidentiality of clinical records. This section of the law is the Florida confidentiality provisions that might be similar to the federal HIPAA laws or 42 CFR Part 2. This section describes when clinical record information may or may not be released and when the information must be released. Next is Section 394.4625, which describes the voluntary admission process for services. It defines who is eligible for voluntary admission and describes the discharge process for a person who has been voluntarily admitted. Finally, Section 394.463 defines the process for involuntary examination. The law specifically states in this section that a person may be admitted for involuntary examination if there is a reason to believe the person has a mental illness, and because of his or her mental illness, the person is likely to suffer from neglect without care or treatment, or there is a substantial likelihood that without care or treatment, the person will cause serious bodily harm to himself or herself or others in the near future, as evidenced by recent behavior. This section also specifies who may initiate an involuntary examination and the required timing of the examination. Finally, the section presents the options for discharge from involuntary examination status. There are a couple of other sections of the Florida mental health law that deserve mention. Section 394.4655 describes the processes and procedures for involuntary outpatient services. This process involves an actual court hearing to determine whether involuntary outpatient services will be ordered or not. The initial order may be for a period of up to 90 days. If the provider believes that continued involuntary services are necessary, they must go back for another hearing with the court that issued the initial order, and again the order can be continued for an additional 90 days, and this process can be repeated. Section 394.467 specifies the rules for involuntary inpatient placement. This is not the same as the 72-hour hold for involuntary examination, but may happen after the initial involuntary examination. The requirements remain the same as for an involuntary examination, but also requires a recommendation for continued treatment by a psychiatrist and a second opinion of either a clinical psychologist or another psychiatrist. The provider must file a petition for involuntary inpatient placement with the court, and the court may order continued inpatient treatment for up to 90 days. Section 349.469 is significant in that it clearly states that at any time a patient is found to no longer meet the criteria for involuntary placement, the facility will discharge the patient or transfer the patient to voluntary status. And finally, Section 394, 47892 addresses the rules for mental health court programs, including pretrial intervention programs and post-adjudicatory programs. Participation in such programs is defined in the law as being strictly voluntary. The second major law that affects the work of case managers is Florida Statute 397, known as the Howell S. Marchman Alcohol and Other Drug Services Act. Again, I want to emphasize that this act sets the landscape for the entire substance use disorder treatment continuum in the state of Florida, not just the involuntary admissions component of the law. A copy of this law is provided in the lesson media section of this lesson, and there are several important sections in the Act that I want to highlight. First is Section 397.410, which establishes the authority of the Department of Children and Families to establish rules for licensure as a substance use disorder treatment provider. The rules are described in Florida Administrative Code 65D, Section 30, which we will discuss later. Section 397.417 establishes the requirement that peer specialists must be certified, and it grants the authority to the Department of Children and Families for developing a certification process. Section 397.501 establishes the rights of individuals who are receiving substance use disorder services. The rights that are specifically described include the right to individual dignity, the right to non-discriminatory services, the right to quality services, the right to communication, the right to care and custody of personal effects, the right to education of minors, the right to confidentiality of individual records, the right to counsel, and the right to habeas corpus. I specifically want to discuss the confidentiality section of this law. The confidentiality provisions of the Marchman Act are not as restrictive as the federal law 42 CFR Part 2. So any facility receiving federal funds must comply with the more restrictive legislation, which is the federal law. The Florida law includes some provisions that are not included in 42 CFR Part 2, specifically delineating how a court can order the release of records and how these records may be used. Section 397.601 describes the process for a voluntary admission to a substance use disorder treating facility. One note on voluntary admissions is that a person under the age of 18 may consent to treatment, and that consent does not require parental consent. Part 5 of the law goes into great detail regarding the involuntary admission procedure. Section 397.675 lists the criteria for involuntary admission. The criteria are essentially the same as under the Baker Act, but instead of a requirement that the individual has a mental health disorder, the Marchman Act requires that the person is substance abuse impaired or has a co-occurring mental health disorder. Police officers may institute involuntary admissions for the purpose of protective custody and in the case of an emergency. Also, in the case of an emergency, a licensed provider can initiate the involuntary admission, as well as a relative, legal guardian, or any other person who has personal knowledge of the person's substance abuse impairment. Sections 397-681 through 397-6978 outlines the process for filing a request for a court hearing for an order for involuntary treatment. Finally, Part 9 of the law outlines substance use disorder treatment services for children, as well as authorizing intervention and prevention programs. When the Florida legislature passes a law, that law typically grants authority to one of the departments of the state to develop regulations for the implementation of the law. So for both the Baker Act and the Marchman Act, that authority was given to the Department of Children and Families. The implementation regulations for those two acts are found in several places in the Florida Administrative Code, where department regulations are published. 65E15 are the regulations for case management services. 65E4 are the regulations for community mental health services. 65E5 are the actual regulations in response to the Mental Health Act. And finally, 65D30 are where substance abuse services are defined. We will talk specifically about each one of these. Florida Administrative Code 65E-15 are the regulations for case management services in the state of Florida. A copy of these regulations is provided for you in the lesson media section of this lesson. There are several parts of the regulations that I want to highlight. First, 65E15.031 defines the priority clients for case management services. The priority populations are individuals who have been referred to, who are currently residing in, or who have been discharged from a state facility. The population also includes clients who were receiving case management services in another county, who have moved into a different county, people who are at risk of hospitalization or incarceration due to mental health issues, people who have been admitted to a crisis stabilization unit, a short-term residential facility, or an inpatient psychiatric unit, persons who currently reside in or who have been discharged from a mental health residential treatment facility, and persons who have experienced long-term or serious acute episodes of mental health impairment who are at risk of requiring more intensive services. Regulation 65E15.032 defines the requirement for intensive case management services. There is a maximum caseload for intensive case management, and staff members must be able to respond 24 hours per day, 7 days per week. The regulations state that in addition to the traditional case management services, intensive case management must also include crisis support services and skills training in the natural environment of the person served. Regulation 65E15.051 describes the role and functions of traditional case management services. In these services, the maximum caseload is 40 clients for each case manager. The regulations describe the responsibilities of case managers to include assessment, service planning, linkage and brokerage, monitoring, and advocacy. There are separate lessons in this curriculum that specifically address each of these functions. And finally, Regulation 65E15.081 specifies the requirements for the items that must be included in the case management record. Again, There is a separate training in this curriculum regarding the required documentation. (65E4) are the regulations for community mental health services. Again, there are several sections that I wish to highlight. First, Section 65E4.014, paragraph 3, defines the requirements for the clinical record for any person receiving community-based mental health services, and the requirement that the organization develop policies and procedures regarding entering information into the record and the maintenance of those records. 65E4.014, paragraph 4, describes the requirements for screening and intake. And then paragraph 6 describes the required processes for the development of a treatment or service plan. It should be noted that while 65E15 specifically addresses the requirements for case management services, 65E4 also applies to case management services as they are part of the community mental health service system. 65E5 is the section of the Florida Administrative Code that defines the regulations for the implementation and enforcement of the Mental Health Act. Again, I'd like to highlight several areas. First, Section 65E5.130 describes the required coordination between receiving facilities and case managers. Upon a person's admission to a receiving facility, the facility is required to notify the case manager, and the case manager must do a face-to-face visit with the person at the facility to assist in coordinating discharge planning and post-discharge placement. Section 65E5.1302 describes the procedures for an admission to a state treatment facility. While the Mental Health Act authorizes admissions to a state treatment facility, this section of the regulations specifically states what must be done to seek such an admission. Section 65E140 through 220 describe the rights of persons served. While these rights are addressed in the Mental Health Act, this regulation provides much greater detail, including examples of permitted and prohibited actions. One thing I would like to note is that this section requires that every treatment program have copies of the Mental Health Act, Florida Statute 394, and the Mental Health Act Regulations, 65E5, and to provide them to individuals upon their request. Section 65E5-250 discusses the confidentiality of clinical records. This section of the procedures is not as detailed as the confidentiality provisions described in the Mental Health Act. And finally, Section 65E5, 270, and 280 document the voluntary and involuntary admission procedures for a receiving facility. The final section of the Administrative Code that we want to look at is Section 65D30, which are the regulations for the implementation of the Marchman Act related to substance use disorder services. In Section 65D30.004, the regulations specify the requirements for all substance use disorder treatment providers, requiring things like personnel policies and records, the types of services which may be provided, infection control, and reporting abuse and neglect. New this year is a section about overdose prevention, including the requirement to inform individuals served about naloxone and where to obtain it. Section 65D30.0041 describes the requirements for clinical records, including information about what is required to be in the record and the maintenance of those records. Section 65D30.0045 discusses the rights of individuals served. This section does not list the rights of individuals. Instead, it refers back to Florida Statute 397.501. Instead, this section includes the process for accepting and processing a grievance based on a violation of those specified rights. Section 65D30.0049 presents the processes for voluntary and involuntary admissions. In this section, the only requirement specified for a voluntary admission is that the person must meet the diagnostic criteria for a substance use disorder. This section does not list the requirements for an involuntary admission. Instead, it refers back to Florida Statute 397.675. The section does talk about discharge processes for individuals who are admitted involuntarily, and the processes used for an assessment that is used as evidence in a hearing. Finally, Section 65D30.005 through .014 describe additional requirements for various levels of care recognized by the Department of Children and Families and the state of Florida. There are 10 levels of care currently recognized. These level of care specific requirements are in addition to the common licensing standards that are presented in 65D30.004. The final section that we want to look at are the Medicaid standards, which in Florida are issued by the Agency for Healthcare Administration. Any organization or service provider billing Medicaid for their services must comply with these standards. There are 3 handbooks that would apply to case management services. First, there is the Provider General Handbook. Next would be the Community Behavioral Health Services Coverage and Limitations Handbook. And finally, the Mental Health Targeted Case Manager Handbook. Copies of these handbooks are provided for your review in the lesson media section of this lesson. We're going to take a closer look at the Mental Health Targeted Case Management Handbook. In the Mental Health Targeted Case Management Handbook, Section 1, pages 7 and 8 detail the qualifications for and the certification requirements for a targeted case management supervisor. Continuing on to page 9 through 11 are the requirements for and certification process for a mental health targeted case manager for children or adults. The certification process is currently administered by the Florida Certification Board, which includes the ACA-approved case management training, which you are completing by completing this curriculum. In Section 2, pages 12 through 14, the requirements for an assessment are presented, including the requirement for a home visit as part of the assessment, the sources of information in the assessment, and what must be included in the assessment. Section 2, pages 15 and 16, describes the requirements for a case management service plan, including the requirement that service plans be completed within the first 30 days of services and reviewed at least every 6 months. And finally, Section 2, pages 20 through 21, specify the documentation requirements for case managers. As I mentioned before, there is another lesson in this curriculum that specifically discusses the documentation requirements. This completes our lesson on laws, rules, and regulations for case management services. Please remember to download and review all of the attachments in the lesson media section of this lesson. These attachments are copies of the laws, the regulations, and Medicaid handbooks. Once you have completed a review of all of the attachments, you are required to complete the attached quiz with a passing score of at least 70%. And finally, a PDF copy of this slideshow is available in the lesson media section of this lesson. Thank you and good luck.